The final topic of constitutional protections, we're going to cover three areas of the Constitution: the right of privacy, the right to bear arms, and the right to not be subjected to excessive punishment. So, right of privacy. Where in the Constitution does it say we have a right to privacy? Which one of those amendments? That was a trick question because it doesn't. Nowhere in the specific language of the U.S. Constitution does it say you have a right to privacy, like it says you have the right to free speech and free press and assembly and bear arms. It actually does not say that. So how did it become a constitutional right? The U.S. Supreme Court has determined that it does say it through its case law, i.e. precedent, looking back through precedent, reviewing the amendments of the Constitution. The United States Supreme Court, in essence, has said the First, Third, Fourth, Fifth, Ninth, and 14th Amendments of the Constitution have established the right of privacy. And because of that, a criminal defendant can raise it as a defense to a particular statute that they're being charged with or crime that they're being charged under. Now, the reading materials in the book give you the pertinent information. This is not something that is commonly asserted in criminal cases. Oh, statute violates my right to privacy. Over time, I think a lot of the privacy issues have been addressed. In the past, we've seen statutes being attacked under the right of privacy where states have made it a crime for married people or consenting adults to use contraception. There were laws preventing the use of, you couldn't use contraceptives. Also with criminalizing abortion, that was deemed a right of privacy, can't do that. And there were laws that indicated consenting adults that were unmarried couldn't have sex. So that was deemed an invasion of privacy. You have the right of privacy to do that. So that's in essence kind of how that evolved, having the right of privacy. I've not seen in those cases, and I believe some of them are cited in the book, have been, in this overturned in the 60s, maybe early 70s, but I haven't seen anything recently with regards to any of those particular laws or criminal statutes being overturned due to the right of privacy. Right to bear arms. The Second Amendment gives us this right, and as you are probably aware, if you are on social media and follow the news, this is a hotly contested amendment. But as I said earlier when we were talking about the Supreme Court has not addressed this amendment much like it has with the First Amendment. And as I explained, after Sandy Hook, New York and Connecticut passed strict gun laws, and it weighed its way all the way up to possibly getting to the Supreme Court. And I'm not going to go into that again right here. I addressed it when we talked about the Supreme Court. So it's not something that has been before the Supreme Court. There are two cases in the book from 2000, one's 2008, one's 2010, that has some restrictions on the Second Amendment, basically it protects an individual's right to possess a usable handgun in the home for self-defense. So it recognizes that we're entitled to own a handgun. But there's also been some restrictions too. Like if you were a convicted felon, you don't have a right to own a handgun. If you have a mental illness, you don't have a right to own a handgun. You can't possess one near schools or government buildings, and there are restrictions with regards to commercial sales of firearms. But that's really the gist of how the laws have been restricted or expanded. Very minimal. And I will leave I think it's like one page in the book for you guys to review on this statute, but it's certainly not something that I have seen raised as a defense in recent years. Excessive punishment. We're going to kind of delve into this a little bit more, even though it's somewhat related more towards criminal procedure. But if we are going to talk about criminal statutes and grading of statutes, when I say grading, I mean when something's called a Class A felony versus a B felony. The reason for those is it kind of has some effect on the sentence that is imposed. So I think this is something that we need to kind of touch on and discuss. And the Eighth Amendment says excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. So cruel and unusual punishments, those relate to the sentencing component, which, like I said, is criminal procedure. There are three areas that we're just going to touch on. What is the infliction of cruel punishment? When is a criminal sentence, or what can be deemed a criminal sentence as too severe? And when can it be invalidated? A criminal sentence is not proper, or did the judge do something improperly relative to a sentence? So let's talk about infliction of cruel punishment. What must the government refrain from doing? Well, inflicting some sort of barbaric punishment on defendants. And this really goes towards the death penalty, using the death penalty, or torture, which was the case in early colonial American times, and actually even after that, up until the late 1800s and early 1900s. That's how people were punished, some sort of torture and or death, or eye for an eye kind of punishment. And you probably covered something like that in an introduction to criminal justice class. I know I do when I teach that class. So let's talk about the death penalty. What did we have when it was just the death penalty? Depending on what crime that you were convicted of, there was, over time that evolved. We had stoning, we had beheading, we had firing squad, we had the gas chamber, the electric chair. Now we have lethal injection. And it is quite a controversial topic. New York State does not have the death penalty, neither does a state like California. And there are 34 of the states in our country have it. And of all the countries in the world, I think the number's 52 countries still use or consider the death penalty for punishment. And if you Google it, if you're interested in this topic, and you Google it, which countries that is, you will see that the United States is, and I'm putting in air quotes, quote unquote, in good company. Some of those countries on the list: Iran, Iraq, Libya, a lot of third world countries, and most of the more urbanized countries do not recognize it. So the Supreme Court has said it is it's not unconstitutional. So it's up to the states to decide whether they are going to have the death penalty or not. It's usually a legislative thing, but there are courts that have said, no, that's unconstitutional under our state constitution. And one of those states most recently who did that was the state of Connecticut. So it's left to the states to decide. A couple points, though, on the death penalty. In 1972, the Supreme Court said that it was unconstitutional for the jury to decide whether a criminal defendant should be sentenced to death. As a result, a lot of states have invalidated that statute that allowed that to happen. The job of sentencing is up to the judge. However, the Supreme Court also said it was constitutional to split that decision. So after a jury finds somebody guilty of a crime, they go back and they reconvene. The state of Arizona does this. They reconvene and determine whether or not the person they should make a recommendation to the judge whether or not somebody should be sentenced to death. But ultimately, the sentencing phase is up to the judge, and the judge can decide otherwise. Why do you think the claim for capital punishment is inhumane? I think the attack goes towards the method of execution. As I just described, it kind of has changed over time, and there's been a couple challenges to the lethal injection, and the court has said that is not unconstitutional. The Supreme Court has said it's not unconstitutional. So that's cruel. That's where our cruel and inhumane treatment component comes from. We certainly aren't involved in torture anymore, so the death penalty is the more common attack for cruel and inhumane treatment. Sentence is too severe, meaning the sentence is disproportionate to the crime. So let's talk about this. This comes up certainly as arguments, and let me give you this example. We have a 15-year-old, let's say we have a 15-year-old who's tried as an adult for murder. But for the example, let's say he killed a family member. He or she killed a family member, and they're tried as an adult. And it's in Arizona, and so there's a recommendation for the death penalty. And the court sentences that 15-year-old to the death penalty. That has been something that has been deemed by the Supreme Court as too severe. Anyone, basically, based on the Supreme Court, nobody who is 18 or younger can be, and when they committed the crime, can be sentenced to the death penalty. Goes towards the age factor. Also, somebody who's mentally ill cannot be sentenced to the death penalty if they were mentally ill at the time of the crime. Now, there's been arguments and cases making their way up to the Supreme Court, and I believe as recent as last year, the argument was we can't sentence this person to death because they were on death row and they were getting ready to be executed, and the argument was, well, they're mentally ill. Well, they're mentally ill now, but were they mentally ill at the time they committed the crime? So the Supreme Court has said it is still okay to execute that person despite the fact that they now are mentally ill. So it's mentally ill at the time of the crime. Also, an example, sentence too severe. Do you get the death penalty for stealing televisions from Walmart? No, that would be a sentence that is too severe. The Supreme Court has held that rape, it would be getting the death penalty for rape would be too severe, even if that is a rape of a child. So basically, it has been left to just somebody who has been convicted of homicide in some fashion. And we'll talk about homicide in more detail, chapter 9, so week 9. The other time we're dealing with a sentence that is too severe is our persistent felony rule. A lot of states, as well as the federal government, have if you continue to commit crimes, your sentence gets harsher each time. That's a common occurrence. And depending on the specific crime, it'll specifically say that your sentence is going to enhance. For simplest of terms, a DWI case. Your first time is usually paying out lots of money. Could you go to jail? Yeah, the statute says you can go to jail, but it's highly unlikely. Second time, and the first time is a misdemeanor. The second time it happens, it's a felony. The third time it happens, it's a higher level felony, and the penalty gets more severe as it continues to occur or there continues to get convictions. In, let's say, drug offenses, drug possession, drug sales type cases, the federal government gives you a 3-strike rule. And a lot of states give you a 3-strike felony rule, not a drug rule. It's just if you got 3 felonies, you can be considered a persistent felony and you can be sentenced to life in prison. And it could be any 3 felonies. And New York has that rule. But to get that, if a prosecutor wants that, to get that, there has to be a full-fledged court hearing on it. It's just not, oh, this person has 3 felony convictions, so give them life in prison. But the drug cases in federal court are a little bit more rigid, and it pertains to drug felonies. And it doesn't mean 3 drug felonies in the federal court system. If you have 3 drug felony convictions about the country in any state, they will be considered to enhance your sentence, and you can be facing 25 to life in federal prison based on drugs. And this has been a challenged a lot because it has such severe repercussions. I mean, I can give you an example where I represented a 25-year-old individual, and he had 2 felony drug sales in the state of New Jersey because he sold drugs, small amount of drugs, happened to be near a school, so it made those felonies, and he did some state prison time on one of those. The other time he got probation, but then he brought drugs with him to the North Country, and he was selling those up here in the North Country, and the feds caught him because he trafficked through from New Jersey. And because of his 2 felony convictions in New Jersey, the judge didn't ding him with the big 25 to life sentence because he was too young. The judge thought he was too young, but he gave him the label, for a lack of a better term, of a persistent drug felon. And the judge made it perfectly clear if he returned to federal court in his lifetime that would be the sentence that he would ultimately get, but he was going to cut him a break. And did he get federal jail time? Yes, and I think he's probably done by now, or was out a short time after. But nonetheless, he didn't kill anybody. So the question becomes, would that sentence have been too severe? Because the judge could have given him that harsh sentence. So I digress. But these things are always up for the challenge to the Supreme Court. Sentencing violates the right of a jury trial. As we all know, the 6th Amendment, you have a right to a trial, and you're entitled by right to a unanimous jury verdict, whether that be not guilty or guilty, but the jury has to decide unanimously. And the judge will decide what sentence happens later. Now, as I was talking about sentences being able to be enhanced, and that is up to the judge, the judge cannot, it says right here on our screen, the judge cannot hear facts that were not present at the time of trial to enhance somebody's sentence. So let me give you an example. 2 examples, actually. So let's say during a trial, the jury hears the facts of a case, and let's say it's an assault case, and the jury comes back with a guilty verdict. And at sentencing, when the prosecutor is asking for what sentence should be imposed and the defense attorney is asking what sentence should be imposed, the judge will make the decision, and the judge may hear something to the effect that this defendant has had 2 prior convictions for what they are. There's a criminal record. There was 2 prior convictions. Now, the jury won't hear that. If a jury hears something like that, they're going to think, oh, this person commits crimes, right? They will never let a jury hear that kind of information because it's prejudicial and it has no bearing on the facts of the particular case. But can the judge use it to decide the sentence. Absolutely. The judge can decide if it's an assault case and the judge has a range of sentencing someone between 1 year in jail and 5 years in jail, knowing that they had a prior criminal convictions and what happened in those cases, the judge will be able to decide which, whether they're going to get 1 year in jail or 3 years in jail or 5 years in jail or something in between that. But that's the range, and that's what they determine. Now, what I mean by facts, they can't do something about hearing new facts, because obviously what I told you is kind of a new fact. It's somebody's criminal history that wasn't heard at the time of trial, but the judge gets to consider it. The judge also gets to consider lots of other things, like if the person has a job or is in school and those sorts of things, to determine a fair sentence. But let's say there's an assault case and the defendant used a weapon, let's say a bat, to assault the victim, okay? And let's say that a assault sentence can be up to 5 years in prison. And that's all that the jury hears. The jury hears that the defendant hit this victim intentionally. Did it, called him, the victim shouted obscenities at the defendant. The defendant got mad, hit him with a bat, and made some damage. Let's say broke his jaw. And he's found guilty. The judge has a job of sentencing, can sentence up to 5 years, picks a, let's say he sentences him to 3. But let's say at sentencing, the prosecutor comes in and makes this big argument that, judge, you know what? Under our law, if this is a hate crime, this maximum sentence you can impose is not 5, but up to 10, because this was a hate crime and the victim was gay and the defendant is known to not like gay people, and that's the reason why the defendant hit him with a bat. Now, if that happens at sentencing and the judge sentences the person, yep, you're right, it's a hate crime, you're going to get 7 years. That is what we're talking about in this example, where the sentence violates the right to a jury trial, because the fact that the prosecutor wanted to treat this as a hate crime, they would have to show that the victim was homosexual and that was the driving force of the defendant's conduct to assault them with the bat. That has to be something a jury has to hear and determine beyond a reasonable doubt that fact before a judge can enhance it. And when we're going to talk about hate crimes and how they get enhanced a little later on. But for purposes of this is an example of the Constitution being violated because the sentence violates the right to a jury trial in this case. Now, one last example before I close up here. Actually, a couple more things I want to touch on. Double jeopardy. You can't be tried for the same crime twice. That's also in our Constitution. I think everyone's pretty on board with double jeopardy. If you are acquitted of murder in the first degree, you can't be recharged for murder in the first degree because the people found a new witness later on. Can't happen. Other constitutional protections, speedy trial. You have the right to have a speedy trial. This is something that's always contested too, because it's not always black and white. Prosecutor has so much time to bring a case, whether it's a misdemeanor or a felony, to trial, not charge somebody with a crime, because as cases like murder, that's something that's called a statute of limitations. There is no statute of limitations. You hear about these cold cases that they reopen back up because murder has no statute of limitations. Speedy trial is once a person is charged, they've been before the judge, they got their arraignment, from that point forward ticks a clock called speedy trial. And the prosecutor has so much time to bring this case to a full-fledged trial. Certainly the clock stops at certain points because the defendant might ask for certain things like, oh, I want a hearing on this issue, or I want to, get an opportunity to read the DA's file. So there are times when the clock stops and then restarts and stops, but there's a particular length of time that it has to get from arraignment to finish. And I clicked my little slide, so I'm going to tell you real quick. Trial by jury, you're entitled, Sixth Amendment, I just said that earlier. You're entitled to have your trial public. The court cannot close off the courthouse or the courtroom for this criminal trial. It's been deemed by the Supreme Court that the public is a right to watch the trial and be aware of the trial and hear about the trial, and the defendant's entitled to have the public watch him or her on trial. This is the government. Remember, the government's taking action. They want to see what's going on. And speaking of public trial, can a judge order a gag order on the press? Gag order is, you don't talk about this case. Cannot do that to the press or the public. Can do that to the parties, can tell the attorneys, you don't talk about this case, you don't hold press conferences. The judge can put a gag order on the parties, but cannot gag the press or the public. And confront witnesses and the accuser. If somebody's accusing you of doing something to them, you have a right to confront them, which means the people have to put them on the stand. And you're entitled to ask them questions about, what they said and their side of things. And that's the easiest confronting witnesses. There are some exceptions for kids and the age of the person and confidential informants, but is entitled to confront their accuser. All right, so I clicked to my final example here. This is in the book. Bill is on trial for obstructing a public sidewalk. Bill was arrested for standing in front of a restaurant's entrance with a sign stating, "We'll eat any and all leftovers." And then the city's law says Bill violated makes it a misdemeanor to stand or sit on a public sidewalk with a sign. To save money, the judge presiding over Bill's trial declares that Bill will have a bench trial rather than a jury trial because it's only a misdemeanor. What do you think? Does Bill have any constitutional attacks on this? And this is a common type of ordinance that gets attacked under the Constitution. This is considered a quality of life kind of law. We're going to talk about those when we talk about crimes against the public, chapter 12, I think it is, and we'll go through more of these types of laws. But based on what you learned in the last 4, not just this video, but the other 3 videos as well, lectures as well, does Bill have any constitutional attacks here on that city ordinance? The ordinance says it's a misdemeanor to stand or sit on a public sidewalk with a sign. Think free speech. And as it's applied to Bill here, being a person on a public sidewalk with a sign, what might you think the government's compelling interest? Because remember, if this is going to go against somebody's fundamental right or challenge somebody's fundamental right, restrict somebody's fundamental right, the government has to show a compelling reason for this law. And maybe their law is to not have somebody just blocking the sidewalk or disrupting the public who might feel uncomfortable with doling out their leftovers. It seems kind of minimal, keep the riffraff off the streets, but I don't know if Bill in this example is really causing any kind of ruckus or concern. I don't say that here. So in this case, I don't know if they have much of a compelling interest. What about the judge's decision? Doesn't matter if it's a misdemeanor. Doesn't matter if it's a Actually, I'm going to take that back on the violation, and I'll clear that up in a second. Misdemeanor, felony, they're crimes. You're entitled to a jury trial. So by the judge saying, nope, you're getting a bench trial, violated his constitutional right, his entitlement to a jury trial. Now, I stopped at ordinance violation and said, well, you don't really necessarily get a jury trial. In New York, I can't speak for other states. It's probably the same in other states. But in New York, you are not entitled to a jury trial if you are charged with an infraction or a violation level offense. Actually, I believe the statute is if you are not going to be subjected to more than 30 days in jail, you're not entitled to a jury trial. And it really goes towards punishment. And if you looked up a speeding ticket, the penalty on a speeding ticket, it actually says you can be sentenced up to 15 days in jail. I've never seen anybody sentenced to jail time in a speeding ticket. I think it would have to have a whole bunch of other circumstances surrounding it. I've seen people who said, well, I'd rather do some time in jail than pay your crazy fine. I'll do a weekend in jail rather than pay $1,000 fine. So I've seen people volunteer that. But nonetheless, I think it's because it's not criminal. When you get a traffic infraction or a violation, you don't end up with a criminal record with it, and your liberty is probably not at stake. I haven't seen it challenged, but that's but for purposes of this misdemeanor, felony, it's a crime. You can get a criminal conviction, lose your liberty. You're entitled to a jury trial. So that ends our discussion on constitutional protections. Chapter 4 is going to start the elements of a crime, and make sure you get your assignments in.